Things like, hey, if you don't pay support, you're not seeing the kids. Don't do that. Or you'll never see them again. Now, these statements like that can be very problematic and cause very serious issues in your case. So today, I want to talk about how the court views text messages and why what you send can absolutely be used against you in family court proceedings. First, let's clear up a common misconception. A lot of people think that text messages are private. I think they send them and nobody else is going to see them. Well, they're not. If a message is relevant to the issues before the court, there's a very good chance that it could end up as evidence. And that means messages about custody. It could be text messages about physical placement or messages about child support. We're talking about text messages that deal with co-parenting issues and how you treat a person. Even messages that were sent when you were angry and you never expected anyone else to read. Now, here's where people get themselves into trouble. They start treating text messages like it's a place to vent. They send insults, they make threats, and they call the other parent names. They send excessive messages, 20 messages in a row, and they demand answers. And then months later, those same messages are printed out, handed to a court, and marked as an exhibit, and it's trouble for you if you're the person who's sending these messages. So remember, the courts are not just looking at what happened, they're looking at how a parent handles conflict, how they deal with hard times, how a parent communicates effectively or not. The courts want to know, can you remain emotionally in control? Can you be calm? Can you put the child's needs ahead of your own emotions? Now, these text messages often answer a lot of these questions. I mean, in reality, right? If you're sending these messages privately, why would a court believe you in court when you say you don't normally act that way, when a person has the written evidence right in front of them? So another mistake I see is parents trying to control access to their child through texting. Things like, hey, if you don't pay support, you're not seeing the kids. Don't do that. Or you'll never see them again. Now, these statements like that can be very problematic and cause very serious issues in your case. Family court generally expects parents to follow court orders and not create their own rules through text messages. Now, I see parents make the mistake of assuming that deleted messages disappear or somehow they'll just be forgiven for what they said, but don't count on that. The screenshots exist, somebody's keeping a record of them, phone records exist, backups exist, and frankly, many people are shocked when the messages that they thought were gone or they forgot about suddenly reappear in court. So here's what you need to do. Before you press that send button and send these nasty messages, ask yourself one question. Would I be comfortable reading this message out loud in front of a judge? That's your barometer. If the answer is no, don't send it. Keep messages brief. Keep them factual. Keep them focused on the child. And remember that every message creates a record that may be reviewed later. One emotional moment can create evidence that follows you throughout your case. Text messages is something that didn't exist when I started practicing law. It's very prevalent these days, and you have to be very aware of what you have already said and what you are thinking about saying. So even if the damage has already been done and you've sent text messages that are inappropriate or not reasonable, the best thing you can do is to change and stop sending those messages in the future. So reach out to us at HKK Law Offices and we'd be happy to talk to you about your family court situation.